Yep. Okay. Go!
Will you hand me my screen box?
Now go preach. On the record in the matter of Brooke Ashley Church versus Bruce Hicks. Potential 23-01873GC.
Good morning, Your Honor. Brian Lowe on behalf of the defendant.
Okay, and ma'am, state your name for the record.
Brooke Ashley Church.
Okay, today's the date that was scheduled to continue a trial. And I requested certain documents to be provided today by the defense. Then you had the right to all rebuttal witnesses based on the defense's witnesses today, if that's what you intended to do. But you have the documentation I requested.
Your Honor, I believe at the end of the last hearing you said that their judicial system had looked it up online.
I told you that you didn't have to provide any documents. And that my recollection was you were supposed to provide me documents that indicated who was the owner of Coast to Coast and Unlimited Potential, because you're a witness, the named defendant one under oath didn't seem to be able to tell the court who owned these companies. Are you calling rebuttal witnesses today?
Yes.
Okay, who do you intend to call?
Bruce Hicks.
You're calling him as a rebuttal witness?
Oh, no.
Or you just want to question him?
Yes, question next week.
Okay, so he can retake the stand then.
Is that now, Your Honor?
Yes. You can have a seat. Okay, you can proceed to question the witness.
Okay, so the last time that we were here, you said that you did not know about me having heat since 2020, correct?
No.
You did not know about, your question was the last time you were here, he didn't know about you having
Yes,
heat?
you
Or not having heat?
not having heat since 2020. You said that you haven't noticed anything about me having heat since 2020.
That's incorrect. We provided receipts to show that we made repairs since 2020.
When was the last time that I told you that I didn't have heat that you recall?
I guess you need to tell me the last time you...
No, you can't answer her question with a question. You have to answer her question.
I don't know specifically.
I wrote down that you said that you did not know that I did not have heat since 2020.
We provided receipts of multiple repairs after 2020. So we have had conversations about it, and the company that sent out multiple receipts were admitted into evidence that shows HVAC repairs happen.
Okay. I have text messages that prove that I let you know every single time, every winter that I've lived there since last winter that I did not have heat, because he stated.
You're asking him questions, so not giving testimony.
Last time.
So your question is, so you're saying that you have text messages. So I guess you would want to ask him, are you disputing that she has text messages where she communicated with you each winter about a heat issue?
I'm sorry, can you?
Are you disputing that she has text message communications between you and her where she notified you of an issue regarding the heat every year?
I guess the answer to my question is whenever repair request was made for HVAC, it was complied with. There are receipts that are on file that date after 2020. There's receipts in 24. There's receipts in 23. There's receipts, and these are all in the exhibits that were submitted to the court.
And what exhibit number is that, Mr. Rom? I have defendant's exhibit E, that is a heating and cooling. That's the only one I have for heating. Is Should the court have another one, Mr. Long?
That was the only one from last time, Your Honor.
Okay, so again, her question, are you disputing that every year she reported an issue with the heat?
I'm not ordering issues with the heat, but
Your statement is that it was repaired.
that is correct, Your Honor.
And you believe that there should be receipts from every year being repaired, or is your testimony that that one receipt that reflects the repair in 2020?
You said 2024, right?
Sorry?
Did you say 2024?
I don't know. I didn't ask him about 2024, but are you saying that the one, I have one heating and cooling receipt from, that was admitted from, looks like the date was July 2022. Are you saying that that would reflect the only effort that you've taken to address the heat, or should there be other records?
There should be other records. Can I go to Brian to get the paperwork?
He's got a bar license. If he has the paperwork, he should be able to pull it while you answer the questions.
Okay. I don't know off the top of my head, Your Honor, so I'll
Okay,
wait.
but you believe you provided him other records for heating, for repairing the heat. I'll let him look for that while you answer her next questions.
Okay, so you guys did provide, documents of the drain, the furnace, the professional companies coming out. Why was there no professional company coming out to fix the porch? No construction company or nothing recorded there?
Well, you just referenced we provided receipts. Are you talking about just the one receipt for HVAC, or are you talking?
The one receipt or any, you provided all the companies for the repairs throughout the whole house, but the steps. Nobody, you didn't provide any construction paperwork or any receipts or anything for that. Is that correct?
No, we provided pictures.
No, it's correct. No, it's not correct.
Ask the question again, please.
You provided professional companies that came and fixed the water heaters, the drain, the furnace, the duct, all those. But why did you not provide a professional company that came and fixed the porch?
I guess one isn't needed, right? Unless you're pulling a building permit, you don't need to have a licensed professional. However, for drains, HVAC, you have to be licensed to work on those. I guess those appliances.
So was it your friend that came and fixed the porch?
No,
You have no personal relationship with the person that came and fixed the porch for me?
when you say a person, do I know them? Yes. Are they
Like
a
a
friend?
close friendship.
Negative. This is a person who's compensated for doing work. This is not a friend.
Is he a professional?
Professional what?
Is he a professional anything?
That's way broad. That's too broad.
Is he a professional contractor, construction?
Let's see.
Is he a professional to fix my porch for me? So that I
Person
wouldn't
is
fall?
competent, and you do not need to have a builder's license to make a repair.
Move on to the next question.
Okay. Were you aware that he was smoking marijuana during him fixing the porch?
Marijuana is a legal drug,
Well, she didn't ask you that.
right?
Were you aware that he was smoking marijuana?
And this is still hearsay. He's not here to defend himself, so I don't know.
That's not hearsay. She's saying,
I don't
and
know
she's
what-
asking you, were you aware?
I do not
It's
know.
just yes or no.
Okay. Have you fixed everything that the city of Lansing has asked you to fix in my rental?
I think the only thing that is outstanding is the permit in which they said, I spoke with them last, the person who did the inspection is retired, so they're just gonna pass.
So the
That's last thing
breaker-
I know.
Let him answer.
Last I knew, all the repairs were made.
So the breaker being labeled is repaired at my house?
Last I knew, it was repaired. I have not physically been there.
I have, the breaker is not.
That you're not giving
Okay,
your argument or your testimony.
Okay.
He's giving answers. And so even if you don't like his answers, you can, I don't know if you have a pen, note that down, and then
Okay.
you'll give an opportunity to give rebuttal testimony if that's what you want, and
Okay.
provide evidence in support of that, but you don't get to tell him what his testimony is going to be, okay?
Is the front deck fixed and replaced like the city of Lansing asked you to do by 3/8 of 2023?
To the best of my knowledge, yes.
I have nothing further.
Thank you. Mr. Lum, did you find the additional paperwork that he referenced?
I do have a, it's John Archer.
Show her. Okay, can you tell me what this is?
This is an HVAC repair. It looks like there was a service call, clean flame sensor and pressure switch part replaced with original equipment gas valve. So this was for the furnace.
This is for the furnace.
This is for the furnace.
Okay, so do you believe that this was done in response to maybe communication you received from her about the heat? Okay, and that was what date?
It's like this one was dated February 19th of 24.
Okay. Any other questions about that issue, ma'am?
It's not really a question, but nobody's came to my house in the past year. Nobody,
Okay,
no
so that's not a
companies.
question. So he can be excused from the stand then.
Okay.
Thank you, sir. You can return to where your attorney is. Okay. And you want to give some counter argument to some of the things that he stated, is what you're saying?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, you can proceed.
Can I start with this? Nobody has been to my house since I filed for this civil suit back in 2023. No company, not Bruce, nobody has been to my house at all. So I don't know where this is from, but nobody has been in the past year to my house.
Okay.
When it comes to the deck, he fixed the steps, but the rental inspection stated the front deck was damaged and deteriorated and the deck boards need to be repaired. That has never happened at all. There was a repair to the steps only because I fell through them when I was pregnant. That's why the repair happened on the steps. But the rental Chief Meredith stated that the front deck and deck boards need to be replaced, and that has not happened at all.
Any other argument? I'm sorry, testimony at this point that you're.
I do recall, I know that everything's recorded, but I do recall him stating that he has had no recollection of me not having heat since 2020, hence why I wrote it in my notes. And I have been begging him for over 2 years about the heat being fixed, trying to get it fixed. Last year, I had to have heaters, and he had to bring heaters, clothes, and everything for my newborn. I mean, I wouldn't be here today if those would have been fixed. So
Okay, and when you said you communicated that to Mr. Hicks,
yes,
how?
text messages, pictures of my thermostat being at 63 when it's set at 74. Text messages first in 2023, and then this is in February of 2024 of the thermostat being 63.59 when I woke up in the morning with my newborn.
Did you show Mr. Lumley's?
The service panel also still lacks the proper labeling at the breakers. Like he said that they came out and fixed it, he did not.
The service paneling?
The service.
Okay, so
yeah.
you're referencing your exhibit 2 where it said that there were certain things cited and the compliance date would have been April 7th of 2023. Section 605.1, service panel lacks proper labeling of breakers. Is that what you're talking about?
Yes, correct. And to this day, they're still not labeled. I have it on my phone because I couldn't print a picture. It was too dark when I printed it. But I have this taken Saturday, and there's no labels on my breakers at the house.
Okay, and so let's see. Are we talking about the photos that you just showed, Mr. Lum? Mr. Lum, are you objecting to those being an exhibit?
I don't To the specific photo, I just have one.
Yeah, these are different days. What do you have? 61, there's one at 63. Oh, these are the, yes, so this one is at 63. That was at 10:40 p.m. This is at 2.
You said no objection?
No objection,
Okay, so that would be, I think, plaintiff's exhibit 3. We can get that from her. Okay, so the first page is supposed to, it's dark. It's supposed to be February 17, 2024 is what you're stating?
Yes, correct.
And who is, this is your phone?
Yeah, this is my thermostat. Oh yeah, that's my phone, yeah.
And you took this and you're saying that you sent this to Mr. Hicks?
Correct.
Okay, and so I think, I can't see the time, but is it about 2 o'clock?
Yeah.
And you're saying that your heat
Should be at the top one is what I have it set at. And
it
then
says 74?
Yeah, and then the big number is what it would just stay at.
Okay. And then I see another message that looks like it was the same date at 10:40 p.m.
Yeah. It just stayed the same. It wasn't.
Okay.
What you could tell it
It's like a
wasn't
61 degrees. Do you have responses from him?
No.
Why not? Why not? How do you just have these and I don't see the full communication?
There was no communication after I served him papers for court.
No, but you sent him these
Yes.
in a text message?
Those were not in a text message. Those were the pictures of the thermostat.
Okay, so how did you notify him about this?
I notified him on the text message, but I had gotten a new phone at that time.
Okay,
So I don't have those text messages from last year of me contacting him about the heat from
but you
last
still
year.
have the pictures?
Yes, I have all the pictures still. The pictures stayed in my Gmail, but the text messages did not.
Okay. Any other evidence or proofs that you want the court to consider?
Other than the breaker, no.
Oh, so you're, just to sum up your issues, obviously the porch and the deck are major concerns for you.
Yes, very much.
Your testimony was that there was some issue with the heat not working
And I see as well.
and the AC not working. You said the plumbing was really bad,
Yes.
that the water, I guess you couldn't take a shower
Yeah, my
or a
son-
tub for
yeah,
a bath for a while.
Yeah. Or the sink in the bathroom as well would be flooded.
Okay, and something about a bathroom sink tub clogged,
Yeah.
to which he gave counter testimony that he provided some evidence to show that he had, looks like it made some attempts to correct the steps, and that's referencing some photos, but that took place multiple times, and one of them, the one that looks like it has some new fresh wood on the steps, that was August 2nd. To update those steps, your argument is he updated the steps after August 2nd, which would have been after your latest fall.
Yes, yes.
And
Well, at least
then-
5 days after.
And then, but didn't do anything allegedly didn't do anything to the front deck boards as cited in the rental inspection.
Mhm.
Is that a yes?
Yes, that is a yes.
Okay. And then as it relates to the heat, you just admitted some pictures that is about your thermostat.
Right.
And these were from February 17th. However, he has a receipt on the 19th. And he sent someone over there, paid $418 to have a repair done in response to that. As it relates to the bathroom issue, I don't see any physical evidence or pictures or anything to discuss that, but we did provide some testimony evidence. He's provided testimony evidence about having service providers come out multiple times. And then also some testimony evidence about some foreign object or substance that was located in the drain. I can't remember, was it the bathtub drain?
It's bathtub, Your Honor.
Bathtub drain.
And sink as well, Your Honor.
Okay, there's some receipts here from Michigan Drain from April 23. Another receipt from Michigan Drain, it says August 2022. Holt Plumbing, February 3rd, 23. This is for heat. His testimony today, though, would be that as it relates to the outstanding compliance for the inspection, the only issue that he believes has not been addressed would be a proper inspection and sticker for the water heater. Your statements would be that it should all that the service panel still lacks labeling.
And the porch as well.
And then the porch. Okay. You submitted a bunch of text messages, but they've not been entered. I don't know if you believe that they should have been entered or that they were. I don't want you to believe these were entered because they were not. These have not been entered. And then you have some text messages, and it looks like urgent care, date of visit February 20th, 2023.
These are all the dates that I've fallen on the porch before the steps collapsed on me.
Okay, so when he submits the picture of the steps being fixed on August 2nd, what year was that?
2023, when I was pregnant with my daughter.
Okay, you had, I see on this urgent care receipt, it says the date of visit was July 17th, 2020.
Yes, I've been falling on the steps for the past 3 years.
Right, but where's the receipt for your hospital visit after, or the 2023 incident?
It should have the wrist splint on there because I couldn't get x-rays.
Okay. I think the concern that I have with these medical records is, number one, when you're submitting documents to the court, you don't get to write on them. You don't get to highlight any of the above. The other issue is that I have this urgent care receipt. It says page 1 of 1. And that's the one that says July 17, 2020. You submitted another page, which I believe is what you're purporting to provide, seen on July 2023 is what it says at the top. But that's page 2 of 3. Page 1 is missing for that.
Okay, I think this may be it then. I think one of these. You said the July 30th and November 24th.
July 30th, 2023.
Yep.
You submitted page 2 of 3 for that medical record.
This is the first one.
I don't have the first page.
This is the first one right here.
That's supposed to be a 3-page document. And then there's a bunch of text messages with some pictures, but I don't know what evidentiary value you believe they hold. So I'm going to let you come and get these here so that you can see what you provided. And if you believe that they have evidentiary value, then you can go into the now. Otherwise, you can keep those, and then we'll proceed to argument.
This is just me begging him to fix the steps after I fell for days and days.
After you fell when?
On July 29th.
Of 2023.
Yeah. I mean, it was days, question marks. I'm literally begging him to come fix the steps. And then when some person came, they brought the wrong wood, and it was another 2 days. And I couldn't take my son to school. I couldn't go to work. I couldn't have people come drop off products. And
you're saying these front stairs are the only stairs for you to enter your home?
Yes. Well, I have the back steps, but at that time I had a garden right there. So being pregnant, I couldn't move it myself. It was full of dirt. So that was I don't ever go on my back porch. That's my only way of coming in and out of my house was the front porch. There's a gate right there. It was just too hard for me to move.
Okay. Anything else about those text messages that you believe show value to your case?
Just me stating that I'm begging him to come fix the steps, and why did they come? Where are they at? I have to get my son to school. I have to make money. I can't leave. I couldn't leave my house. I couldn't get down anywhere. Me asking him to fix everything.
What's everything? Are you
just
saying
the-
those text messages show you asking to fix something other than the porch?
Yes, the water heater, when I was like, my water light bill is so high because the water heater's leaking.
What date was that?
This is, I think these are all literally the same day or same week up to that.
I don't know what that is. What date?
It would be, the month of July, 2023.
Okay, so you sent a text message in July 23
Yes.
about your report of water and light.
Yes, the water heater leaking, my water light being high. There's text messages about him missing payments and if I have any to send him. I admit that I can't go on the back porch. I can't lift the heavy gate with the bin of dirt in it. Can you please fix the steps? I asked him again, how long am I gonna be without steps? I'm pregnant, I can't get down, I still have a life, I still have to take Logan to school, my neighbors had to take him. And he just tells me, tell this all to the attorney. There's also me telling him about the permits that he was supposed to fix the deck and the breakers by that date, and he hadn't fixed them. The water heater not being fixed. Him not being in compliance with the city of Lansing. So I do believe that these all should be submitted.
You can show those to Mr. Long.
He also has a copy of those as well.
And so it's your argument that he does not currently have a valid rental certificate?
I think that when I called Meredith, he didn't have it that day, but she told me that he went there the next day and got one.
Okay. City records today show it's on hold. Do you have anything to dispute that, Mr. Long?
According to my client, the reason
So I didn't ask. The reason was I said, do you have anything to dispute that it's currently on hold?
any documentation.
Right, that he has a valid, up-to-date certificate because the city website says it's on hold. Any other, or as it relates to those text messages, are you just objecting to those being exhibits? Or you can go over those with your client at any time?
I would just object to the ones that don't have dates on them.
So the objection is that, and I think it's reasonable, if they don't have dates on it, they can't serve to show when that communication took place.
This is the whole thread, so it never stops.
You know, if you get that from the August 14th. This is all 2023?
Yes.
So you're saying this is the whole thread and it's being admitted in order?
I don't know if it's in order right now.
Yeah, because it's definitely not in order, because I'm looking at timestamps. Some say page 2 of this, the first 3 right here, all say page 2 of 3. First 4 say all page 2 of 3. So some things are missing. One page, where's the first pages are in all of these? I don't know that this is a conversation that goes in order.
Yeah, I don't know if it's in order at right now. No.
Well, how am I supposed to read it and follow if it's not in order?
I can put them in
Just
order.
for example, this says, it ends with tell all this to the attorney. I tried to talk to you, so you didn't want to talk. So there, nothing to, and then it goes there, it doesn't finish.
Yeah, I have to put them in order for you right now if you'd like.
Okay. I'll let you put this in order.
Okay.
And then you can show Mr. Lum again, now that it's in order, and maybe his objection will change.
Okay.
Okay, you can be seated. Mr. Lum, you still have an objection?
I would just
Those are
read me my
separate.
objection for the ones I don't have dates for.
Okay, so these are what?
One is focused on the rent payment that he's asking me, and then the other one is focused on strictly the steps.
Okay,
So they don't have times back to back because they're all a conversation.
Okay, so
you know?
August 14th is about the steps.
Correct.
It's August 15, 2023.
This is before I fell,
And you asked about,
or after. Yes, before after I fell.
that you fell in July 2023.
Yes, I meant to say after I fell. This is afterwards.
Okay, and you're referencing having permits on 415 and fixing the deck
Yes.
and the breakers and outlets by the date. That's what that's about, correct?
Yeah, but basically fixing
14.
everything that's going on with the house.
Okay, this is an ongoing conversation.
Yes.
The 14th, it's still on the 14th, but this can't be in order because this, well, maybe it goes through.
Some of them are screenshotted where I double take, you know, you can see the conversation and then I take another picture of the conversation beforehand as well.
Yeah, so the issue is that then there's no dates, and so if you have a camera roll, it should have the date that the conversation started, like this says the conversation started on August 14th. And then obviously this probably is part of that same conversation.
Yeah, after, underneath it, yeah, that's just the way that my camera was set up.
Right, but I at least can see that this says, this right here is exactly what this says. It's just the
Yeah,
portion that got
yes.
cut off.
Yeah,
And then this has a date on it. This starts with okay, the last page ended with okay. The issue that I have then is, I don't know how this goes into this. I gotta have time. I have a baby, OTW. I'm not about to move during that. And then it goes, I'm not going to keep paying 120 extra a month. I don't know if that's the same date because the timestamps are different. The time at the top of this is
that's the time that I
1:46.
screenshotted it, I'm pretty sure. The time at the top in the corner. Yeah, those are the times that I screenshotted the text messages.
So I don't know, I don't have any way of knowing that this is, that conversation flows in this, because you're talking about two different things. Talking about, I'm not gonna keep paying an extra 120 a month, and this was talking about having time to move. On August 14th.
It was me saying everything all in one. That's where all the text messages are. He's just complaining to him honestly.
Okay, I'm gonna grant this objection. I'm not admitting anything that doesn't have a date on it, because it's too difficult for me to try to figure out if these conversations align that way. Let's see, on this one, you're talking about fixing the porch, that's on July 30th, and then Monday, the 31st. And then there's dates of July 31st, August 2nd, and then it's August 2nd.
I guess it's just the way that my phone like screen, it doesn't show kind of on the iPhone.
Any other, and I'll admit these separately, since you're saying they report to discuss different things.
It's all really the same thing, him not fixing things in the
I can
house.
do it in order. So these were all 2023, so it looks like it started in July, at least July 27th on these. And then that last page, that I need to admit is August 14th. I'm not going to admit those pages because I can't tell when that was. And so that would be plaintiff's 4. And then your urgent care receipts.
Oh, did you read the first one?
You had one from February 20th, July 17th. And then it was supposed to be one from July 30th, 2023.
This is the July.
This might be the first page. Does the first page look like this?
Yes.
I think it's out of order. That's the
The
issue.
July. Is that for July?
July 30th, 2023.
Yes.
Okay. Let me see what you have there, Yolanda.
July 30th.
It might
No,
look
it
like,
doesn't look like my first page. Okay.
it doesn't look like that.
Okay, this is
The first page.
the first page.
Okay.
Okay. And you turned over a copy of these medical records as well.
Yes. To him and to.
Okay, so I'll have the medical records as plaintiff's proposed exhibit 5. Any objection to the medical records?
Oh, just object to the extent that there's any missing pages or anything.
Yeah, I think that the missing page issue has been corrected because she provided the first page for the 30th of July 2020. That was what was missing for that. Well, that exhibit will be omitted as plaintiff. I think that's the only other thing that we need. Some pictures of the home or bruises. Pictures of some bruises. I don't know who you sent these pictures to. That's Shelley. I don't know.
That's him when he had his, the other phone that he had.
Shelley is him.
Yes, those are him. He had a phone where he was sneaking to text me or whatever it was, a WhatsApp or text-free number or something like that. So those are all those text messages from
He
him
was
as
sneaking
well.
to text you. What does that mean? He was sneaking to text
It was like I said, we had a personal relationship for this and he's married. So,
Okay, you can skip him. Give her those so that she can look through those messages, because I don't know if it was your intent to have those admitted in some.
the pictures.
Yeah, because there's pictures of some bruises and.
Yeah, but this is when I fell, all the times that I've fallen off the porch with this is the porch before it happened, the eaves trough that Mark fixed that he wouldn't come out and fix. The nails, like the nails coming up on the porch from me falling the porch completely.
Okay,
Yeah, these are all times that I've fallen on the porch where I went to urgent care.
okay, you can show Mr. Long, you can make any objections to that.
He has a copy as well with these two.
Subject to the text messages that don't have dates on them.
I'll look at that as to the extent that they're not obviously a carryover to the same conversation. I'm not gonna spend time trying to figure out what dates those things happen. But to the extent that they have dates, I'll admit them. You want to do that? Yes. Okay. And I think that's all the proofs that I have in the file. And so I have your exhibits. I'm gonna include the admitted exhibits on this under your last exhibit, which is 5. And then, let's see, we have the defense A through, correct, Mr. Long?
That's right. And then this receipt from today.
I just attached it to the other receipt that he had already admitted for cooling, so that's part of B. Okay, so you can make your argument, ma'am, as to why you believe you should get recovery.
It's just like all the times that I've missed out on my business and just the stress of not, like the porch is my kids, not having heat and air for years. I've lived there. I mean, waking up freezing, having to get water heaters or space heaters, having him bring multiple ACs. I mean, he wants me to pay rent in a house that has central air, but I have window ACs in every single room to keep my house cool. You know, the water heater leaking, the times that we couldn't bathe, and it's just stressful because I love the home and I just wish that he would come and fix it. And it's not that he comes and fixes it in a timely manner. I mean, it'll be days and days and days, and those things are important. And it's not just a crack in the window or the screen ripped or anything, things that I would fix myself in that home. But it's serious things, like the porch is serious. And I begged him for years until I was pregnant and fell down the porch, and then he had to do something, and he still didn't do anything within the 24 hours or 48-hour period. It was still days afterwards that he had somebody come, and they were smoking on the job, and it's just like, how did I know that the steps were put in properly? You know, it was just it was just depressing and stressful the whole time I've lived there. And it's a great home. It has great potential, and I love my area. I love my neighbors. I love the house. My kids love it. They were raised there. So it's just, I wish that he would fix things. I mean, the drain problem is back to back to back to back, to the point where even the drain company came in, was like, he's gonna have to put in some money that he really doesn't want to do underneath here with the pipes. You know, it's just kind of being cheap about things, you know?
If you're having all these issues and it's major issues, as you stated,
Yeah,
for years, and it's causing you stress of this magnitude, why would you live here?
because there are things that I know that he can fix. It's
No.
just,
That doesn't mean, just because you know that they can fix it doesn't mean it. So why would you stay here?
I love the area. I love my neighbors. My kids go to school right down the street.
Find another house in the area. Why wouldn't you do that?
I know,
How do
I
you
just
think
love
that
the
how do you think that this landlord-tenant relationship is sustainable?
if he were to fix the porch and the drain, I'd be fine. Those are the only, in the air, I'd be fine. Those are the only main things that I would like him to fix.
You want to fix the porch and the drain, and you said you'd be fine.
The porch, the drain, and the
Like
air.
you said, and I don't know because it's hearsay and it wasn't admitted, but let's say, for example, there was a major drain issue, which is common in this city. It could be an issue because of plumbing going into the piping, who knows? Well, let's say that's the case and it's major, it's gonna cost him a lot of money and he doesn't want to put that money into getting new plumbing done. What are you gonna do?
Well, Mark has actually snaked the drains so that the drains work better than they have before. So the drain, the snake, now I have my own snake where I can do it myself if it were to be plugged.
Okay, so the drain issue's not a major
The
issue because
air-
you snaked it.
The air is the issue. The
The
air and
AC,
the porch.
the fact that there's no central air is a major issue for you.
In the porch, the wooding coming up.
Yeah, the porch is something that was cited by code compliance.
Yeah.
They're not citing air conditioning, because you know why?
Yeah.
It's not a major issue, that's the luxury. We don't have to provide you
With the
central
heat-
air.
The heat in there, I think that.
Heat is different,
Yeah.
but AC, no, we don't have to provide you central AC. You have some units that you can use in your window, like you said. Heat, you need heat.
Yeah.
And so, but if the representation is that he's kept this home in such disrepair that it's interfering with your enjoyment of the home or your use of the home, that it's not fit for the use it's intended for, then I don't know how you can, in the same sentence, say that you love the home.
I do, with all of it, even I do. I love the home. I put in work to it myself. It's just those two things that I feel like he should fix, and I would be fine. It's not like I'm asking for a lot. I mean,
Well, if that's the case,
or
what are we doing here? Why don't you all negotiate this outside of here? You fix this and I'll drop the lawsuit. Why don't you all do that?
it hasn't been fixed. I'm not sure why.
Okay, Mr. Lemon, you can make argument.
Your Honor, it's the plaintiff's burden to prove all the elements of a legal claim to establish damages. I believe Ms. Church has proved all of the elements of the legal claim, which would be duty, breach of that duty,
I don't believe
causation.
she proved breach of a duty to repair the stairs
And damages.
and damages. You don't believe that?
I don't believe she's ever given us a number of damages that she's.
Well, we can hold a whole separate hearing on damages though, and you know that. But she just has to prove that she suffered some damage. The court can evaluate the damage themselves.
To the extent of a personal injury claim prior to August 2nd, 2020, I would argue that prior to that is required by statute of limitations for personal injuries.
Is there anything prior to August when?
August 2nd, 2020, 3 years prior to it's being filed.
I agree.
My client, when he's been notified of repairs, he's done his best to get over there and make those repairs. As evidenced by multiple receipts. Plaintiff needs to notify the tenant of any repairs that need to be made. This is my client's position that she hasn't met all of the elements of the legal cause of action. And we ask that. And I think,
Thank you. Any further argument from you, ma'am?
No, Your Honor.
Okay, so, you filed a civil action, claiming, some damage. I think you were seeking recovery in the amount of $15,000, I believe is what stated in your complaint. You said you wanted to relocate. And you said but you did say that, you wanted to relocate because he would evict you, because of this cause of action. Maybe you are not aware, but the law does protect you from retaliatory eviction. And so, the law protects you from a retaliatory eviction. So there is a presumption, I guess, of an eviction. If you go home and next week you get an eviction on your door, there's a presumption that because of the time frame, it's likely retaliation. Doesn't mean that you can never be evicted. Also doesn't mean that you don't pay your rent.
Right.
And that presumption is not going to grant you, any kind of indemnification to stay in his property forever. I don't, just listening to this and seeing how this case has played out over the 2 days that I've seen you all, I don't even know how or why you would want to stay in his property. I don't know how it would be healthy and beneficial to you, as a mother, and someone who's in a relationship, to be in a home where you've indicated you've had a relationship with this individual, the intimate nature. You should probably want to pack your things and sever that relationship and give him his property back. I don't care how much you love the home. There's plenty of homes in the city of Lansing that look like that home. And so, but to say that he's caused you this amount of stress and then present evidence to show that not only has it caused you some stress, but to show that you've had some supposed injuries because of the lack of repairs to the property, it just doesn't make sense to me that you would continue to want to be in that environment. Nonetheless, you're alleging damages from a fall from the stairs or multiple falls. Again, you indicated that you fell February 2020, July 2020, and then that you fell on July 30th, 2023. Again, as indicated by Mr. Lum, there's a statute of limitations on certain claims. Do I believe that you sustained or presented enough evidence that will sustain a burden as it relates to the fall? I absolutely think you did. You demonstrated via text messages that you made communication multiple times about the stairs, almost to the point where it appeared she's begging in these text messages about some stairs being fixed. There has been evidence submitted both by the plaintiff and by the defendant that shows pictures of the stairs, and the plaintiff presents pictures obviously very different from the ones that were presented by the defendant. The plaintiff shows pictures of after the fall that shows wood that is clearly deteriorated, and there's a whole step that appears to be missing from the top of those stairs, and the nails that have or won't even be, they wouldn't, there's nothing that could be done with this wood and these nails based on what I'm seeing to cause these stairs to be put back together. There was some testimony from your witness, Mr. Carmack, that he did make some attempts, I guess, to fix the stairs or the gutters or something to that nature. The defendant did submit an exhibit and testify that on July 29, 2023, that there was an attempt to fix these stairs. And the court can see even in the photos where after this repair took place, there's some rusted loose nails there. And then it appears that even after this has been replaced, that there's just gross deterioration to the integrity of this wood. And that was what was supposed to be your repair on July 29th. And so now there's allegation that after that she falls on the 30th. Now we get new wood. Now we fix it so that she doesn't fall. Well, she's put on notice beforehand multiple times. What about these stairs? Wasn't repaired. She uses the stairs. She falls down. He's liable. How much he's liable for? I don't know. I don't have any medical bills. I don't have any records here that shows me that she had a loss of wages, that she had to go to get any treatment, any physical therapy. None of that has happened. I'm going to have to set this for a whole nother hearing for her to present some kind of evidence, because all I have now is that there was a fall. And I believe that the fall happened because the stairs were in disrepair, because I have multiple pictures showing me that. And then I have pictures in text messages that show the bruising, as well as medical records. The medical records, although I've agreed with the defense that there's a statute of limitations on the previous claims for falls in 2020 because of the statute of limitation. But we have pictures of bruises and stairs after that she's sending to him to show that there had been a history that expanded 3 years regarding these stairs. That's ridiculous. Stairs could have been fixed for very little money. And responding to a request from your tenant about stairs being fixed to, well, are you going to pay your rent? That's a separate issue. She does need to pay her rent, but you need to keep your property in repair regardless of if she pays the rent. If you don't keep your property in repair and a delivery person, that let's say the mailman comes to walk up those stairs and he falls, you're liable. Doesn't matter that she didn't pay her rent. You're supposed to keep it in repair. And it's not just for her consumption. It's reasonable that somebody could come and deliver something and fall through those stairs. And then now you created a risk of liability for yourself because you didn't want to fix the stairs because she didn't pay the rent that you thought she should pay, repair. As it relates to the air conditioning, and it's unfortunate. It would be nice to have central air. I don't know. You've not presented me a lease that said that was part of your lease agreement. You're just telling me that the place was supposed to have central air. It's broken. He didn't fix it. I'm not sustaining that cause of action because I don't think it's necessary for your rental conditions. Heating, however, is a necessary issue. I did see some text messages about the heat. I see obviously the way you presented evidence in your exhibit regarding the temperature in the house. However, he's provided the satisfactory evidence to support that he sent somebody to take care of that heat, at least in 2022. And then again, 2 days within 48 hours of one of the pictures that you sent. I was going to say, I don't know that your pictures show me that you sent them to him because you told me you don't have that phone. Mm-hmm. But the date on this is within 48 hours of that date. So it's reasonable for the court to conclude that he received those text messages and then responded by sending someone out to have the heat replaced. And then I don't see any communications or any screenshots or pictures after this date showing that, well, we still didn't have heat even after this happened. And you're saying that no one appeared. Maybe someone appeared and you weren't there and they just failed to tell you notice we sent someone to get it fixed. I don't know. He got a receipt. He paid $418. This is the services that was provided. And it was for the location where you live. And you haven't provided me anything that rebuts this by saying, well, even after February 19th, I still didn't have heat. This is where I told him. On February 20th, no, the heat still is not working. This is where I told him in March, hey, it's snowing outside. You've not provided me any evidence. Typically, when I get cases where people are saying I don't have heat, well, what happens is they wouldn't got a hotel room while the heat was being replaced because they got kids and they couldn't stay warm or whatever the case is. And they bring me those receipts, something that shows me that you suffered some damage. So you have to have, it can't just be a duty and a breach. There has to also be damage in order for you to get a cause of action. So as to whether or not you had an issue with getting heating, I believe you did. but I think he cured that issue within the reasonable time under the statute, within 48 hours, which is reasonable to get that heat addressed. I have multiple receipts from a drain commission. I think that there's been an ongoing issue, just as much as there's been an ongoing issue about those stairs, about this drain. And I see where he's spent some money and sent people out multiple times. You didn't call any witness, or the person that you said told you that there was a bigger issue. There may be a bigger issue. I don't know. But I also heard your statement that you have found that snaking the drain is beneficial and has caused there to be better drainage. And they're likely, I don't know if you have large trees on that property. I don't know if there's roots that are going into the drain. I don't know. But I have testimony from the defendant that that there's been some discussion or some issue in the past about putting some substance, rocks or something, I don't know what it is, into the property, and how that likely could have caused some backage of the drain. I don't know whether that those are things the court can consider, but I don't know if that's the case or not. Drainage can be slow for a number of reasons. You got a lot of hair on your head.
Yeah.
I'm sure your children probably have a lot of hair. That could back it up. I have to snake. I have curly hair. I have to snake my drain sometimes too. It happens. It's just a nature of what's happening. But you're not presenting me anything that shows where the conditions of the drain have been such that it causes the use or the fitness of the property to be below the standard. And I have evidence where he has sent someone multiple times to address the drain issue. So I'm not going to sustain a cause of action for that. As it relates to compliance with the law for the certification and the code compliance issue, I think he's conceded. Yeah, I haven't gotten the sticker. The city website indicates that he's not, that his certification is on hold as of right now, probably because he hasn't gotten the certification. It sounds like he did get a new water heater, just didn't get it properly inspected so that the city can be satisfied. I don't see where they've been back out to that property, where they've red tagged the property or pink tagged the property. He does need to get that issue addressed. But obviously there's a new water heater there, no? So that means he's been doing something to try to maintain that issue. And then there's a issue as it relates to the breakers not being properly labeled. I don't believe he was aware, maybe, or he disputed that. It's clearly stated here that the service panel lacks proper labeling at the breakers. And if that's the case, it needs to be done. But you not showed me where, and that, so there is a duty there, but you not show me where that caused you some damage because he didn't do it. You have to show me where, because he didn't do it, you suffered some kind of loss, monetary or physical of some sort, because he didn't do those things. And that's not the case here. It's just something that you can hold over his head. And to the extent that he doesn't get it done, I guess code compliance can come back out. But if they pink tag or red that property, then you got to go.
Mm-hmm.
So I'm not going to sustain a cause of action for that. The only cause of action I'm going to grant you is on, or as it relates to the slip and fall, because you did give prior notice according to the law of the issue. He acknowledged notice of that issue in some of these text messages. It was not properly addressed, and because of that, you fell. Now, I don't know what the damage was. You have not presented any medical bills that you have paid. You've not presented any evidence of what your loss of wages would have been, but that you could not sustain that. You could not get that money because of the injury that you sustained.
I thought I had receipts
You've not, you provided those to Mr. Lum.
to both of them, to both of you.
Receipts as to what?
Yeah.
Everything that I have, I gave you back, so I don't have any
Yeah,
receipts.
it was like missing, like I do placenta encapsulation, so all my business receipts that I had.
Business receipts. Okay, so I'm gonna hold a separate hearing for that because it's 107. I have another docket that's coming in, and it's not your fault that this other docket carried over, the interpreter was late. But I'm going to actually require that you have a conversation off the record with Mr. Lum. You all can do it today if you'd like, so that you can go over these receipts and see if you can, to see if he has any dispute. If not, if he is going to, if you all want to concede on an amount or agree to an amount, consent to an amount, for what you believe her loss was or her damage was. You're not getting $15,000, and I don't, unless you could show me that you broke your leg and you had to have some surgery or something, or unless you got some receipts in there that show me that you would have made $15,000.
Okay.
Your requesting, your summons was that you wanted $15,000 to relocate, not that you suffered a loss of $15,000. That you wanted that so you could relocate because he was going to evict you because of this lawsuit. Eviction and where you live after this is not before the court, but I don't know how you all are going to work this out. Other than at some point, you're going to probably want to find or make other arrangements, because I don't see this getting any better.
Okay.
But that's between you all and not before the court. So I'm going to give you a date to have a hearing on damages, because Mr. Lum does not appear to have what you believe or you purport to support your damages. Do you have that, Mr. Lum?
The only things I have are the three receipts.
Yeah, you're gonna need to provide him with some financial records. I don't know if you had medical records or co-pays that you had to pay, or if you had to go to any treatment, but you need to provide him some authentic records as to the loss, financial loss that your work business would have suffered because you fell.
Mhm.
And you have to be able to show that it was because you fell. Okay?
Okay.
Because you can still get a cause of action and it's for $1. Okay, sounds good. Let me get you a date. September 18th at 9:30. We're going to exchange your records with him so that you all can have an off-the-record discussion before you come in here.
Okay.
You're all set. We'll get you on this here.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.